Hello, everybody. Welcome to our free webinar series. We'll allow just a moment for everyone to get logged in and then we'll get started. Hey, welcome to everyone out there. So welcome to the Gilbert Training Group free webinar series. This is a session in a series that we are presenting to kind of give you a taste of what we have to offer here at Gilbert Training Group. So today we're going to be talking about latest developments in reasonable accommodation law. We're very excited to see all of you out there virtually. Before we get started with our program, we did want to make sure everyone knew that this is a small portion of a presentation that we will be presenting in 2 weeks, a more in-depth version called Nuts and Bolts of Reasonable Accommodation Training. That's going to take place on September 24th and 25th. This is a 2-day course that will walk attendees through the complete reasonable accommodation process from start to finish. Everything from identifying if somebody is an individual with a disability, are they qualified, looking at essential functions. We're going to talk about direct threat analysis, as well as other claims that can arise under claims of disability discrimination, such as disability-based harassment, direct threat claims, and unlawful medical inquiries. We'll also talk about the undue hardship defense, which is something that we always hear from agencies. They're a bit unsure about how exactly to articulate such a defense. So Torrin, our moderator, is going to put a link into the chat for the registration for that 2-day program. And we hope that you will join us for that in 2 weeks from now. We do have a large crowd today. Appreciate everyone joining us. We'll go over this in a moment, but we do ask that you use the question and answer box if you do have a question for me today. That helps us really keep track and make sure that we can answer as many of your questions as we can. Also, if you are interested in applying for CLE credit for attending this webinar, please email us at the contact information that's going to be in the chat. And for a small fee, we are able to assist you with applying for that CLE credit. So we are going to get started here with our materials. Please feel free to ask questions as we go along. And I'm going to have up here on the slide 2 ways that you can ask questions. As I mentioned, the question and answer box is the best way because it allows us to keep track of the questions. I will try to answer questions as we go along. I may elect to hold a question until we get to materials and slides that relate to your question. If you are not able to use the question and answer box for whatever reason, please feel free to send an email and our moderator, Torrin, will be able to submit it to make sure that I see it there. In your questions, we do ask that you not use any identifying information, names, or sufficient detail that somebody who may be attending this also from your agency or may be familiar with the employee in question may be able to identify who you're talking about. So please use hypotheticals. Don't use such identifying information that somebody may be able to determine who you are talking about in your question. So a little bit about me before we get started. My name is Deryn Sumner. I am managing partner of a private law firm in Silver Spring, Maryland called Gilbert Employment Law. And there I am the chair of the federal sector EEOC practice group. And I represent employees and a few employers before the EEOC and representing them on claims of employment discrimination regarding all the bases protected by federal law, but I do have a focus on representing employees in claims of disability discrimination. I also do trainings, just like this webinar that you're attending today and the full 2-day program that we'll be offering in a few weeks. I also write some books in the area as well. Just recently finished updating a book called Representing Agencies and Complainants Before the EEOC, as well as some other books, including one all about disability discrimination law that I co-author with Gary Gilbert. And those are all available through the publisher we work with, Dewey Publications. So let's get into our material today. So keep in mind that the most important mantra, I would say, when we're looking at an employee coming to us with a request for reasonable accommodation, is to really march through the analysis in an ordered area. And problems we see are kind of knee-jerk reactions, focusing on, well, how are we possibly going to be able to provide what they're looking for? Do we have to do that? This is going to create an undue hardship. You want to take a pause, and with disability discrimination cases, it's really important to make sure that you are walking through the analysis step by step to see, is this person even covered? Are they qualified to do the job? And are we going to be able to provide the reasonable accommodation? Is it a reasonable accommodation that's going to help them be able to perform the essential functions of their position? So keep in mind that if an employee comes to you seeking a reasonable accommodation, you want to start with, are they an individual with a disability? And after the ADA Amendments Act of 2008 that went into effect in 2009, the answer is most often going to be yes, unless we're dealing with a transitory or a minor medical condition. If somebody is able to identify a physical or mental impairment that substantially limits a major life activity, they are most likely going to meet that definition of being an individual with a disability. Now, more in depth is going to be, are they a qualified individual with a disability? Are they able to perform the essential functions of the position that they have been hired for, or that they are seeking to receive through applying for a position, with or without reasonable accommodation? And that's where you get a little more nuanced, because you're looking at the job itself, and you don't want to be focused too much on the black and white of what a position description says. You want to be looking at what is the job itself day to day, and is this individual with their substantial limitations, are they qualified? Can they do those essential functions with or without a reasonable accommodation? If so, they are entitled to an effective reasonable accommodation, perhaps not the reasonable accommodation of choice, but an effective reasonable accommodation to allow them to continue working. And the commission is very focused, the EEOC is very focused on making sure that employers are meeting that obligation, that they are identifying that there are accommodations that can be provided to somebody to allow them to be able to do their job and continue working. Now, there is, of course, the ability for an employer to show that it would be an undue hardship to provide that accommodation. And that does require a showing from the employer of an actual undue hardship with some specificity. We don't allow employers just to simply say, hey, no, this is going to be too hard to provide. We're not going to do it. Because the commission is going to push back on that and say, was there an alternate effective accommodation? Are you actually able to back up your showing of the fact that it is an undue hardship to be able to excuse your obligation to provide an accommodation to somebody who has a disability in the workplace? So we want to kind of identify some issues that we do see time and time again with these requests for accommodation. One being, hey, somebody's asked to telework, and the supervisor says, nope, I want everybody in the office. We do have to take a step back and look at, is this an accommodation that does need to be provided? And is telework going to be the most effective means to allow them to be able to work? And we'll talk a bit about that. We'll talk about some cases where the commission has looked at telework as a reasonable accommodation, but we do see issues from supervisors just saying, no, that's not enough. You got to walk through the analysis, and you have to see, are there alternate effective accommodations that could be provided? Is it that we're looking at too much of the means by which an essential function could be performed as opposed to the essential function itself? We want to make sure that we are not falling back on things like, well, we really want people to engage in face-to-face communication. The commission has been clear that's not going to be enough. If somebody does need telework as a reasonable accommodation, that's not going to be enough to justify denying them, if that is in fact the accommodation that's going to allow them to continue working. Also, another issue that we see is the misunderstanding of the use of leave as a reasonable accommodation. Oftentimes, there are concerns that somebody requests a reasonable accommodation to allow them to be able to do the essential functions of their job. And the employer says, oh, well, if you're having problems in the workplace, then you do have sick leave available to you. That's not allowing somebody to be able to perform those essential functions because they're on leave. They're not in the workplace. They're not doing their job duties. So we want to make sure that we are focusing on when leave is an appropriate accommodation, because sometimes it is. Sometimes leave is what an employee needs if they're adjusting to medication, if they're recovering from a medical procedure or surgery. Then yes, sometimes what they will need to receive as a reasonable accommodation is leave. However, if we are substituting telling an employee to take leave in lieu of providing them an effective accommodation to allow them to do the essential functions of their job, the commission is not going to favor that and is going to find that agencies have failed to provide an accommodation. So we do have a question here. If an employee can still perform the essential functions of their job, but they cannot get to the office to accomplish them due to a disability, does the agency have a responsibility to consider a reasonable accommodation? So I'm going to kind of pick apart this question a bit. The agency always has a responsibility to consider a reasonable accommodation whenever an employee puts them on notice, and we'll talk about this on the next slide here, of a need for an accommodation. We want to make sure that we are recognizing when an employee is requesting reasonable accommodation, because all they have to do is put the employer on notice that they need a change to some kind of term or condition of their employment because of a medical condition. They do not have to use magic words such as reasonable accommodation. They don't have to use a specific email address or make a request through a specific portal to start that process. They can just engage in a verbal conversation with their supervisor, with their manager, with anybody else reasonably connected to the reasonable accommodation process, or somebody can make that request on their behalf. So this is why training is so important, because we need to make sure our supervisors and managers recognize what is a reasonable accommodation and what do I, as a supervisor or manager, have to do when somebody lets me know that they need some kind of alteration, change to their work environment because of a medical condition. So you always have a responsibility to consider a reasonable accommodation. We'll talk about, maybe they're not entitled to it because they don't actually have something that rises to the level of a disability. We may have an issue where, somebody doesn't provide the medical documentation that we need to be able to assess it. And we'll talk about a really interesting case from the commission recently on that issue of medical documentation. But you do always have to consider, even if the ultimate conclusion is you're not entitled to an accommodation or we can't give you the accommodation you're requesting, but we can talk about alternate effective accommodations. Now, getting back to the first part of this question, can the employer, if the employee can still perform the essential functions of their job, but they can't get to the office to accomplish them, do we have a responsibility to consider reasonable accommodation? Yes. There were cases from the commission earlier that kind of focused on this idea of whether or not commuting was something that had to be considered in a reasonable accommodation. The commission has been clear, if an employee is putting you on notice of concerns about getting to the workplace, that does start that reasonable accommodation process. And you do need to consider reasonable accommodation. If they're able to perform those essential functions, then potentially you have an issue where you do have to consider telework, because that may be the most effective accommodation to allow them to continue to work if they can, in fact, perform those essential functions remotely. And we'll talk about some cases illustrating that. So, talking about when you can request medical documentation, keep in mind that not every request for reasonable accommodation is going to necessitate requesting medical documentation from the employee. If the employee has already provided information that places the agency on notice of their disability, their medical condition, if it's known, then that's going to be a situation where you don't need to request medical information. Same thing if the disability itself is obvious. If somebody has an obvious visual impairment or physical impairment, then you're not going to need to require them to provide medical documentation in most instances. However, there are situations where you do need to request medical information from an employee, either to verify that they meet that standard of being an individual with a disability, that they can do the job, they're qualified for the job, or perhaps because you need information about how the reasonable accommodation is going to allow the employee to perform the essential functions of the job. Sometimes the employee is the best source of that information, and sometimes you do need the medical care provider to weigh in and provide that information. However, nothing requires you as an employer to obtain documentation. You can simply take the employee at their word and focus on, can we provide this accommodation? However, it is important to keep in mind that if the disability is not obvious, the need for accommodation is not obvious, and the employee refuses to provide medical documentation about their disability and their need for accommodation, then the employee is not entitled to a reasonable accommodation. And there are situations where the commission affirms this conclusion. And we'll talk about that on the next slide here. Recent decision, Cole E. versus Department of Navy. This is a commission decision from February of 2024. And so Mr. Cole E., and if you don't know, the commission uses pseudonyms when referring to employees in its decisions. So that's not his real name. He was assigned the pseudonym when the decision was issued by the EEOC. He was a supply management specialist, and he said that he was high risk for COVID-19 because of asthma, and he needed reasonable accommodation. And the agency said, okay, we're just going to need some medical documentation from you in order to support that request for accommodation. And here the employee refused to provide it. And although he provided some medical documentation, it didn't explain how the requested accommodation, which here was to work the second shift, would allow him to perform the essential functions of his job. So the commission said it's okay for the employer to request additional medical documentation in this situation. And I have here a direct quote from the decision, because I think it's really strong, interesting language from the commission. We cannot find that the agency acted improperly in requesting additional medical documentation. The interactive process required by the Rehabilitation Act is not a one-way street, and complainant cannot place the entire burden on the agency to be proactive in requesting and obtaining the required medical documentation for his own accommodation. So I think this is really nice language, kind of illustrating from the commission, agencies, we understand that there are situations where you need medical documentation, and if the employee is not cooperating with that request, then you don't have the obligation to provide the accommodation. And the burden is not entirely on you. This is the employee who is requesting the accommodation. They need to take responsibility for providing the information that is required for you to be able to respond and talk about effective reasonable accommodations. So we're going to talk about some specific accommodations that we know, and I know from doing these trainings and talking to colleagues out there in the field, the issues that we see time and time again, and kind of the hot button issues with reasonable accommodation. One of those, of course, being service animals and emotional support animals in the workplace. I highly recommend, we have the URL here on the screen, a website, the Job Accommodation Network. Their website is askjan.org. And it's a wonderful resource that talks about accommodations, medical conditions, and provides a really good resource to think through what options are there for specific accommodations related to specific medical conditions. So you can actually, identify a medical condition, for example, ADHD, and it will provide you with a list of potential accommodations to consider that may or may not be helpful. It's really important to keep in mind that we want to engage in a individualized assessment interactive process with the employee to be able to identify what will work for them, because it's not a one size fits all when we're talking about accommodations. But it provides grounds for brainstorming and for thinking through what may work, what may not work, what can we provide, so that you can have that interactive process dialogue. So when you're faced with an accommodation to bring a service animal into the workplace, you want to treat it like any other accommodation. First, you want to walk through, is the employee an individual with a disability? Are they qualified? Can they perform the essential functions of their position with or without reasonable accommodation? And then if so, let's talk about, does the requested accommodation allow them to perform the essential functions? Or is there an alternate, still needs to be effective, alternate reasonable accommodation that would allow them to perform their job? So we have some wonderful specific questions here to help guide the specific accommodation of service animals in the workplace, including what limitations are they experiencing and how do those limitations affect the employee? What specific job tasks or functions are problematic as a result? And what resources are available to the employee to help them be able to perform those essential functions with a reasonable accommodation? Have we talked to the employee about what their service animal provides in terms of services to them? And something that's important to keep in mind is that service animals can provide a variety of services to employees with disabilities. Obviously, we know about seeing eye animals that can assist people with visual impairments, but there are also animals that can be trained to identify when somebody may be about to experience a medical episode, such as epilepsy or low blood sugar, or a cardiac event, and are trained to notify the individual such that they can seek either medication or know that they're about to be experiencing a medical event. So I think these list of questions here provide a really good kind of framework if you are facing a situation where there's a request for service animals in the workplace. I know it's an issue that we hear about many times, concerns about bringing animals into the workplace. Isn't it going to pose an undue hardship? And we have kind of been waiting for the commission to speak more about the parameters of service dogs or emotional support animals, other service animals in the workplace. And we do have a recent case from the commission, it was just released at the end of July, that speaks to this very idea of when a service animal does pose an undue hardship in the workplace. So this was a mechanic with the Department of Army, and he requested to bring an animal into the workplace to accommodate him with PTSD. And the animal is described in the decision as essentially a puppy who perhaps not even had been house trained yet. And the complainant had been paired with this animal through the Veterans Service Canine Association, and the dog was in training with the complainant to help provide him support for his PTSD. So he brings the animal into the workplace, and immediately there are, concerns, especially because the complainant worked as a mechanic, and there were concerns about hazardous chemicals on site. How was the complainant going to be able to carry out the required training in the workplace? Is the dog going to be in a crate all day? How is this going to happen? And so the complainant shows up with this characterizing decision as a puppy, and basically this puppy is, it seems to be undisputed, not particularly trained very well yet, jumps into the trash can, jumps over other people when the puppy sees them, and basically is creating a bit of a disruption in the workplace. So the agency did exactly what it should have done, and it said, okay, we're gonna need documentation, we're gonna need to consult with a variety of departments and different stakeholders here to figure out if this is something that we're going to be able to address and allow in the workplace. The complainant was not willing to provide much medical documentation or other documentation regarding the animal. He accused the agency of essentially trying to delay the process and not allow him to get what he needed. And he files an EEO complaint. And here the commission, I think is really helpful for those of you who are dealing with this outside in your agencies. The commission said, look, the agency did have a need to request medical documentation. And when it wasn't provided, in coordination with the fact that this puppy was not actually allowing the employee to perform the essential functions of the job, plus the fact that it would be an undue hardship to allow this animal into the workplace, there's no liability on behalf of the agency for not allowing the puppy to remain. And in fact, the agency is able to establish an undue hardship defense. So supporting it is the fact that the commission says, we emphasize that the service dog was an untrained puppy who jumped into the trash can. The complainant refused to provide any documentation regarding future training that the dog would undertake, or even its vaccination status. And the complainant worked in an industrial site dealing with heavy machinery, hazardous chemicals, and loud noises. So basically not a place where an untrained animal should be. Here, the agency viewed it as the animal creating a direct threat in the workplace, and the commission said that's not the legal analysis you want to be looking at. In fact, you want to look at this undue hardship, and we are going to find that you did meet the standard of being able to assert an undue hardship, and therefore we're not going to find any liability for your decision not to allow the animal into the workplace. So I think really helpful for practitioners to be able to point to a case and say, this, now we have from the commission, this is a situation where a service dog is going to pose an undue hardship and is in fact not going to be permitted in the workplace because of that undue hardship that it poses to operations. So we're going to move on to the next issue that we see a lot of consternation regarding: requests for telework, specifically full-time telework in the workplace. It is important to keep in mind that telework may be an effective accommodation for employees in a lot of situations. If they have difficulty commuting, if they have difficulty once they're in the workplace, traversing from the metro station or the parking lot into the workspace when they're there, are there long walks to the restroom, long walks to the entrances and exits. Also, putting aside kind of physical impairments, what about environmental issues? If you have somebody who needs to be able to control the temperature or the air quality, there may be ways that you can provide that accommodation in the workspace. And if so, then you are going to be able to an alternate effective accommodation. But there may be situations where the employee can more easily control that environment at home or an alternate workspace. And so you want to keep in mind that telework may in fact be the effective accommodation to address that. Similarly, you think about medical needs that the employee may have. They may need very quick access to a restroom, and having a restroom that's not always accessible to them or is too long of a walk away may pose difficulties to them, and in fact can lead to very embarrassing situations. There's several cases from the commission in recent years talking about employees who needed to have that quick access to a restroom, and when they were not able to, they ended up experiencing soiling themselves in the workplace, which of course, nobody would wish upon an employee. Just a very dehumanizing, embarrassing event to have to experience. Similarly, there may be other medical needs, such as needing to take medication receive treatment, being able to engage in stretching, standing breaks as they need. That just is easier to do when they are in their own workspace. Flexibility in their work schedule, being able to get in their 8-hour day, if your agency offers that flexibility, as they can, taking breaks as needed, or there's something about the workplace that is impacting their ability to concentrate. There's too much outside noise. They're having problems with the lighting or, anything else that they can point to. Again, this does not mean that telework is always going to be the accommodation that needs to be provided. However, it may be that telework is going to be the effective accommodation. So you want to, as an agency, explore are there alternate effective accommodations that would allow the employee to be able to come to the workplace. Perhaps we can change the lighting, perhaps we can change their workstation so that they are closer to a restroom. Perhaps we can give them a white noise machine or move them to an office with a door that's away from people going by, so that they are able to concentrate more easily. These are all potentially effective alternate accommodations that can be provided. However, keep in mind, it does need to be an effective accommodation. And we see time and time again, employers run into issues where they say no to telework, but then the proffered alternate accommodations are not effective to meet the employee's needs. And the commission is going to conclude, hey, that's not okay. You need to be able to provide an accommodation that is effective. Telework in this instance was in fact the effective accommodation, and agency, you are liable for not providing that effective accommodation. Now, as we all know, however, there are jobs that you do need to be physically located on site to be able to perform those essential functions. For example, we have here TAD S versus Department of Veterans Affairs. This is a EEOC case from earlier this year, and the complainant worked as a radiologist, and he was in fact the only full-time radiologist serving the North Florida, South Georgia Veterans Health Systems facility. So he had a large swath of coverage that he needed to provide to serve and provide medical care to our nation's veterans in his role. And he requested to be able to telework full-time because he was having difficulties concentrating in the workplace because of anxiety, depression, and OCD. And the agency said, look, we cannot allow you to telework full-time. You need to be on site to be able to review the films as a radiologist, and we don't have anybody else that we can kind of ask to do this work because you're the only full-time radiologist serving this geographic area. So as a result, we can't offer you telework, but we could move you to a new office. We could give you a white noise machine, just the ideas that I just mentioned. We can give you additional time to review those files so that hopefully, you don't get overwhelmed, you're able to do your essential functions. And, we think that these are effective alternate accommodations to allow you to continue to work. The complainant disagreed that that was going to be an effective accommodation and filed an EEO complaint alleging that the agency failed to provide him with an accommodation as required under the law. And the commission reviewed and issued a decision saying, in this instance, because of your role as a radiologist, because you are the only full-time radiologist serving this geographic area, your essential functions do require you to be on site, and therefore telework is not going to be an accommodation that allows you to perform your essential functions. You have to be qualified for the job, and the job requires on-site presence. Additionally, the agency offered you some alternative accommodations to address the very concerns that you were having about your ability to perform these essential functions, such as the new office, the white noise machine, giving you additional time to complete your work. So this is a really nice example of where there are job duties that require employees to be on site, and the commission is understanding of that. And so long as the agency has thought about alternate effective accommodations that could be provided, then it's going to avoid liability for not providing the accommodation requested by the employee. So we have a few questions here. How long does an agency have to respond to a request for reasonable accommodation? There is no black and white line, there's no number of days that the commission is going to find needs to be abided by. Your agency may have internal policies that require that a request for accommodation be acknowledged and responded to within X number of days. But when we're looking at the EEOC, we don't have a hard and fast rule. However, the commission has found that delays in providing reasonable accommodation can, in some instances, constitute denials of providing reasonable accommodation. So we want to make sure that we are responding to requests for accommodation in an expeditious manner. And I always recommend that the process itself be documented in writing to the employee. And if there is information needed from the employee to continue on with the process, that is very clearly stated in writing. We have received your reasonable accommodation request of September 6th. We do require medical documentation from your medical care provider to identify X, Y, and Z. Please provide this information by September 24th. If you need additional time because you can't get an appointment right away or whatever else, please let us know. But we are not able to act further on your request until we receive this information. Now, when you're looking at delays where the commission has found that a delay constitutes denial, they're also going to look at how complex was the requested accommodation. And so if it's something like the employee needs a new ergonomic chair, the commission is going to say, look, more than a couple months, what are you doing? You just need to place a purchase order, get the chair in, we're done. If it's more complex, involving constructing a new workspace or installing software that perhaps the agency has never used before, the commission is going to give a bit more leeway in terms of how much time needs to pass for it to be considered a delay. But also keep in mind, you want to be addressing what's happening to the employee in the interim. Do we need to provide them an interim accommodation so that they can continue working, perhaps allow them to telework while that workspace is being constructed? Or what else can we do to show that we are in good faith trying to accommodate the employee while the accommodation is getting into place? Another question is driving to work a major life activity. So major life activities are addressed in the commission's regulations. They fall into generally two categories. One is going to be the things that we do day to day: lifting, standing, walking, reaching, things like that. And the rest, the second category are kind of more internal functions, your cardiovascular system, vision, endocrine system, things like that. So driving is not specifically enumerated in the commission's regulations as a major life activity, but you want to look at, well, what is impacted that causes difficulty for the employee to be able to drive? Are they substantially limited in vision or another major life activity where they cannot drive? So maybe not look at the function itself, but look at the underlying reason why they're having difficulty performing that function. Okay. So as I mentioned, full-time telework is going to be something that needs to be provided when it is appropriate in specific circumstances. And again, we want to use that interactive process to identify what is the position at issue and what are the medical needs that need to be accommodated by telework. And we have a recent example from the commission here, the McHale S case, Social Security case from June of this year. And here the employee did request, she was a claims specialist, and she requested to be able to full-time telework as a reasonable accommodation. And I'm sorry, it's a he. He did request to be able to telework as a reasonable accommodation. And the agency said it's going to be an undue hardship. In your role as a claims specialist, we have people coming in, we need to serve the public, and if you're not here, you are compromising our office's ability to be fully staffed and serving the public. That's all well and good, except that the agency did not back up its assertion with any actual data or evidence. And so the commission found this is not enough. You cannot merely say it would be an undue hardship. You need to explain why, and we'll talk about in a few slides here the factors that agencies need to go over to be able to establish an undue hardship, because it is going to be something that needs to be justified in writing with supporting documentation to be able to assert as a defense to why we're not providing a reasonable accommodation to an employee. So here the agency did not provide any data and evidence, and let's see. And they did not, although they alleged that it provided him with effective alternate accommodations, the complainant argued that they were not, in fact, effective accommodations. Also important here, the complainant argued, look, I was able to perform the position remotely during COVID-19, and so that should be evidence that I can, in fact, perform those essential functions. The commission has released some guidance that talks about how performing your job duties remotely during COVID-19 may serve as kind of a trial period of the effectiveness of telework going forward. However, they are clear that they understand that employers may have chosen to remove essential functions during that time, or change the manner or means by which essential functions were performed during that time. So the fact that your employees were perhaps working remotely is not a be-all end-all to support that they need to be able to telework full-time as an accommodation going forward. However, it can be used as an example as to the effectiveness. Again, it's going to be that interactive process, and we want to look at the job itself, the employee themselves, when we're making that determination, and really avoid making blanket determinations as to whether or not something is going to be effective. So in this case, the commission said, you know, you did not meet the ability, the defense, the factors that we require. They characterize the agency as implying that its ability to serve the public would be significantly hindered, yet the record does not offer any evidence showing the extent to which walk-ins required face-to-face interaction with the complainant specifically. They did not explore methods to alleviate perceived negative impact arising from granting full-time telework. For example, the agency could have solicited volunteers to decrease their telework days, utilize resources from its district office at the same location, or allow complainant to interview walk-ins remotely. The agency could also eliminate the need for full-time telework by transferring or removing the coworker who is creating the concern, the trigger for the employee, to another office. Ultimately, the agency has not provided sufficient argument or evidence to support an undue hardship affirmative defense. This means that not only did the agency fail to provide an effective accommodation, but the commission said now you have to look into what remedies do we provide the employee to compensate them for this, including compensatory damages, which can be a maximum of $300,000. Okay, so let me glance here at the questions before we move on. Is the employee's submission of a VA benefits letter a sufficient substitute for a doctor's note for their physician? That's going to depend on what is in the VA benefits letter and what the agency needs to be able to respond to the request for accommodation. You know, if we're looking for a diagnosis, a prognosis, to be able to establish if they are an individual with a disability, then potentially the VA benefits letter would have that information. If we're looking at information about how a requested reasonable accommodation would allow the employee to perform the essential functions of the job, the VA benefits letter may not contain that information, and so it may not be sufficient. It's really going to depend on what exactly your agency needs to be able to move forward the request for accommodation and respond to it. If an employee asks for a 50% reduction of workload as a reasonable accommodation, does that rule them out as a qualified individual? Potentially, yes. If if the employee has, for example, a requirement where they need to meet certain production standards, the commission is clear that you do not need to reduce or eliminate production standards as a reasonable accommodation. Also, you never need to take away an essential function as a reasonable accommodation. So potentially in that situation, it could result in the fact that their request demonstrates that they cannot in fact perform the essential functions of their job. However, you want to be engaging that interactive process because potentially there is something underlying that can be addressed about the workload generally. Perhaps, the means by which assignments are given to the employee could be in a clearer manner to allow them to be more organized and on top of job duties. So you're still going to want to engage in that interactive process before you immediately say, well, you're saying you can't do half your job, you're no longer qualified, you're not entitled to an accommodation. Okay, I'm going to hold the telework question that we have because we do have a case that talks about telework and performance issues. So let's move on to another specific accommodation that we see a lot, leave. Leave, as I mentioned, may be an effective accommodation to address an employee's needs for medical treatment, rehabilitation services, physical therapy, recuperation from an illness or an episodic manifestation of a disability, for example, recovery from a seizure, or adjustment to a new medication. They may need to be out of the workplace so that they can adjust to a higher dosage, figure out side effects, work with their medical care provider to get that dosage correct so they can function. Or potentially if they are getting repairs on a mobility device that they need to get into the workplace, they may need to be on leave to allow them to get those repairs. However, as I mentioned, leave should not be offered in lieu of an accommodation where there is an accommodation that would allow them to be able to work. If there is something that allows them to be able to do their job, then that does need to be provided. We cannot say, you have leave, use your leave, because every employee in the federal government, luckily, has paid leave as a benefit. And so telling them to use something that everyone gets is not going to be considered an effective accommodation. And we have here a quote from a case the commission came out with a few years ago now. While an employer may choose between effective accommodations, forcing an employee to take leave when another accommodation would permit an employee to continue working is not an effective accommodation. So we have another recent decision from the commission addressing leave and the intersection between leave and reasonable accommodation, and that's KCS versus VA, a case that came out in May of this year, earlier this summer. And so this employee was a medical instrument technician, and she had anxiety, ADHD, and PTSD, and she requested to be able to start her workday earlier as an accommodation, and the agency said, yes, we are able to do that. She then called out sick because, people get sick. And so she utilized her sick leave, and the agency said, whoa, if you're not coming in at the time that you said you needed to come in as a reasonable accommodation, then we're taking away the accommodation. It's obviously not effective if you need to be taking leave. And so she had to file an EEO complaint, and the commission said, hold on a second, agency, you cannot predicate the provision of a reasonable accommodation on an employee's usage of accrued leave. You might have been upset that she called out, she wasn't there in the early morning when you're expecting her to be, but you are basically serving to punish her by revoking the accommodation that she needs when she is utilizing sick leave, which she is entitled to use. So something to keep in mind. There was no showing of undue burden to the fact that the employee had called out sick, and it was very clearly intended to punish the employee who needed to take sick leave, even though she had the altered schedule as a reasonable accommodation. Okay, so as I talked about earlier, responding to a question, there are situations where the commission has found that delays in providing reasonable accommodation do constitute denials of reasonable accommodation. So our practice pointers, in order to insulate, hopefully, your agency from such claims that a delay constitutes denial. Document with specificity any reasons for the delays. Is it on the employee's end? Are you waiting for the employee to provide more information before you can move forward? Are you waiting for a vendor to get back to you? Are you showing that you've made you've obligated funds for a purchase, you're just waiting for it to come in? Get it all documented so that it's clear if there is a challenge later on, you can show what the agency was in fact doing. Document expected timeframes, confirm who's responsible for each task. The commission does not look favorably on claims of, well, this person was supposed to do it, but it sat on their desk, they forgot about it, or they, were on leave and nobody dealt with the, the ordering of the chair for 4 months. The commission is going to say, you as an agency as a whole are responsible for providing reasonable accommodation to employees who are entitled to it. Make sure you know who is handling what and who is responsible for what. And as I mentioned previously, if you do need information from the employee to be able to move forward, put that in writing so that they understand that the process and moving forward is pending your receipt of that information. Again, an illustration of when a delay does result in a denial. We have a VA attorney with PTSD, and he requested to be reassigned to a non-litigation position because of medical restrictions he had as a result of service-connected PTSD. The agency ultimately did move him, but it took 19 months in order to respond to that request, and the commission said that was an extreme delay. During that time, you were still providing the employee with work outside of their medical restrictions. You were not attempting to accommodate the employee in good faith, and therefore, not only did you delay in providing the employee with a reasonable accommodation, such that constituted a denial of accommodation, but in fact, you did not engage in good faith attempts to accommodate them, and they are going to be entitled to compensatory damages as a result. Okay, undue hardship defense, as I mentioned, and as we saw earlier in one of our cases, generalized conclusions will not be sufficient to support a claim of undue hardship. You have to make an individualized assessment of the circumstances at issue to show that it would cause difficulty, significant difficulty or expense. Keep in mind with the federal government, when we're looking at expense, it's going to be very hard for an agency to show that a cost of an accommodation is so expensive such that it is an undue hardship. When we are looking at a small business, that's going to be an easier sell. But when we have the federal government and the budget that is given to agencies, most accommodations only cost a few $100s, if that. So pointing to the expense is very rarely going to be sufficient to be able to meet that undue hardship. So what are the factors that we should be considering when we're looking at undue hardship defense? I think that the most compelling factor that agencies can point to are the impact on the operations. And again, that's going to be an individualized assessment based on where the employee works, how many people do the same job that the employee does, how big is the overall facility. And when we teach this course, we use the example of somebody who works in a postal facility in rural Maine. They are not able to lift packages over 10 pounds. And the rural post office in Maine maybe only has 1 or 2 other employees who work there total. So it may pose an undue hardship in operations if the employee says, look, I can't lift any packages over 10 pounds because you only have 2 other people that could potentially do it. And what happens if they're not working that day or they're on leave? How is the post office going to be able to function with this restriction in place? Now take that employee in rural Maine and place them in the postal facility in Baltimore, Maryland, where you have hundreds of employees performing that function. That's going to be a harder sell in terms of showing that providing something for this employee to do within the restrictions is going to pose an undue hardship, because you have so many people out there who could jump in, who could be assigned those duties. You have other work that can be done within the restrictions. So I think that's going to be the most compelling factor when you're looking at factors to be considered with undue hardship. So we do have a situation here with an undue hardship defense being established, and it does go back to the question that we received earlier, which is, can telework be denied when an employee is having performance issues. So Clarion L is a Department of Defense case issued earlier this year. And she was a health systems specialist, and she requested to be able to telework full-time because of various medical conditions she had, including PTSD, hypervigilance, migraines, nausea, depression, kidney disease, blood pressure, and heart disease. She had previously been approved to telework, but she had performance issues that persisted while she was teleworking. And so the agency said, look, we can't allow you to continue to telework as a reasonable accommodation because you're having these performance issues. And in fact, you know, we can't monitor your performance. The complainant failed to communicate while teleworking. Her performance issues, in fact, worsened while teleworking. The agency placed the employee on a PIP because of concerns about her performance. And so here also the agency said, look, we cannot allow you to telework because of these performance issues. We still have an obligation to provide accommodation. So here are the alternate effective accommodations that we can provide. So they gave her noise canceling headphones, earplugs, they advanced her sick leave. They sought out a private isolated office space with dimmable lights. And worked through, are there any other places that we could place the employee to address kind of the reasons why she needed to telework, which seemed to be based on problems concentrating, things like that, allow her to be able to perform those job duties in the workplace while also being able to keep an eye on her because of those performance issues. So this is helpful for those of you who may be saying, well, we have an employee who does have documented performance issues. How can we work through if telework is a reasonable accommodation? I will caution you, if you're on the fence as to whether telework would be an effective accommodation and you're concerned about performance issues, it may be best to actually provide a trial telework period to see if in fact it is an effective reasonable accommodation. There's a case from the commission, I believe 2018, Natalie S. versus VA, that talks about giving the employee a trial. And if it works, great, you have an effective accommodation. If not, you have a really nice defense to showing that it would in fact not be an effective accommodation because those performance issues in fact got worse while they were allowed to telework. Okay, so one last question, is problem with childcare and need for change of shift considered a reason for a reasonable accommodation? So again, I only have what's written here on the screen. If it is somebody who is saying I can't work the night shift or the day shift because of childcare issues, it does not sound like they are placing the employer on notice of a medical condition that is impacting any kind of major life activities. So it does not sound like that would be a reasonable accommodation. So I would say that, you know, again, just based on what we have here, that's probably not going to fall within the realm of reasonable accommodation. You do want to keep in mind that if it is a request for accommodation because of pregnancy or anything resulting from childbirth, keep in mind that the Pregnant Workers Fairness Act, which went into effect last year, we got some regulations earlier this summer, does speak to obligations an employer has to accommodate employees with pregnancy or related medical conditions. Okay, great questions we had. Thank you so much for all those great questions and for your attention today. So as I mentioned at the outset, this is a series of free webinars that we are offering to kind of give you a taste of our full trainings here, which we have up on the screen. Advanced Employee Relations is coming up next week with Barbara Hago, who's a wonderful speaker about employee relations issues, as well as reasonable accommodation. We have some coming up on compensatory damages and absence and leave issues. If you are interested in receiving CLE credit for attending today, please send us an email, and for a small fee, we can get that processed for you. Also, please, 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 we are going to send you a link to a survey after the webinar ends, and we would very much appreciate if you just take a few minutes and fill that out for us. Give us some feedback What caused you to sign up for this webinar today? Would you like to attend our paid training? And are there issues that you're seeing in getting that approved or otherwise being able to attend that maybe we can help with? Because we would love to see all of you at our programs in the future. Thank you so much for joining me today. We hope to see you again at another Gilbert Training Group event. Thank you so much.